Hi folks, Tony DeWitt here, Missouri appellate attorney, retired, and a guy who just likes to try to make the law make sense for people like you. There's lots to get into today, so let's dive in. Yesterday I was reading through a case involving post-conviction relief, and I was trying to explain to my wife what the procedural problem was in that case, and she kept asking me about the appeal and why was this different than an appeal. And it occurred to me that if my wife, who has spent the last 30 years with me, didn't understand about how people routinely use the law to get out of jail, that it might be a good idea to try and explain that. So today we're going to take a look at what happens when somebody gets arrested and then they get convicted, what the things that are done in relation to that in terms of springing them from jail, shall we say. Now, I think this is something that flies underneath the radar for the most part. I don't think most people realize that after the trial where someone is convicted, someone, for example, like Jennifer Crumbley, is convicted of a crime and sent to jail, that there is a continual process after that, essentially, A, to make sure that her conviction was valid. That's the direct appeal. B, to make sure that her lawyers did a good job. That's the post-conviction relief proceedings. And then C, the appeal of the post-conviction relief proceeding. And then state and federal habeas corpus. There's all kinds of different procedures that go on, and they can go on for years and years. And you, as a citizen, probably never hear about them. So today, we're going to take a look. So the first step, of course, is the criminal trial. So let's talk a little bit about what happens when the criminal trial starts. First of all, if you don't have private counsel, if you can't afford the $50,000 to $75,000 that it would cost to get a defense in a criminal case, for at least a serious felony case, then in most cases the state is going to pay for you to have a public defender. And in cases where it's a capital case where the state's asking for the death penalty, you're probably going to have 2 lawyers at a bare minimum. If there are facts that are undeveloped that your lawyer doesn't have access to, if there are any questions that need to be resolved through the evaluation of witnesses, you can get the state to pay for an investigator. And the state pays for expert witnesses if DNA is involved, for instance. And of course, the trial begins with the presumption of innocence. The defendant is presumed innocent until he's proved guilty. And in order to prove him guilty, you have to do it, the state has to do it beyond a reasonable doubt, which is not beyond any doubt, it's beyond a reasonable doubt. The defendant is entitled to any jury instruction that is supported by the evidence. So, for example, if Jim says Joe attacked him with a knife and the state didn't find the knife, but Joe testifies that he was attacked, then he is entitled to a self-defense instruction because his testimony is evidence. They don't have to find the knife. His testimony, if it's believed by the jury, is sufficient basis for a jury instruction on self-defense. So you can see that in most respects, the trial is sort of stacked in favor of the defendant. Or at least that's the way it appears. In fact, on evidentiary issues and on close calls, most courts almost always side with the prosecution. That's just the ballpark that defense counsel play in every day of the week. They don't like it any more than I do, but that's the way the world works. Uh-oh, you got convicted. Now, the trial attorney will file a motion for a new trial or a motion for judgment notwithstanding the verdict or both, and he will try to eliminate the judgment that way. But if that doesn't work, the next step is an appeal as of right. Now, in almost every state, if you have a death penalty case, you have an appeal as a matter of right to the state Supreme Court. You may, in some states, go through an appellate court first, but you always have access to the Supreme Court on a death penalty case simply because they feel like they want to weigh in on that. So what happens on appeal? Well, the first thing is the lawyers are going to say the trial court made errors. There are a number of errors that they might assert. The indictment was bad. The prosecution committed misconduct. Any number of things that can be raised as an error are raised in this direct appeal. And if you know about something and you don't raise it, you are considered to have waived it. So you take sort of a snapshot on the day of conviction, and whatever the evidence is and whatever the facts and errors are at that point, those are the basis for your appeal. And you make that appeal to, like I said, either the state Supreme Court or an intermediate appellate court. If the appellate court believes that the trial court made errors, it can reverse the verdict and remand for a new trial. Or, in some cases, for example, if there was insufficient evidence, if the state did not provide a sufficient quantum of evidence to justify the guilty verdict, they can order the defendant released. They can vacate and forbid a new trial on the basis of prosecutorial misconduct. And of course, throughout this process, the state pays for the attorney or the attorneys, and the state pays the costs of the appeal, which are not insignificant. A trial transcript can be over, 5,000 pages, and that's a pretty serious bill to pay, particularly for an appellate lawyer or somebody who has an appellate lawyer who is paid out of their own funds. So again, these are not inconsequential rights. Now, if the appeal doesn't go anywhere, then you have access to what's called a post-conviction relief motion. In Missouri, these are called 2915 motions because Missouri Rule of Criminal Procedure 29.15 is what they're based on. And there are strict timelines for filing them. They do not have to wait for the appeal. In other states, they have to wait for the appeal. But in Missouri, anyway, they don't have to wait for the appeal to be concluded. Here, they bring up new issues that have arisen. For example, the witness who testified at trial that they saw you with a handgun has now recanted their testimony because they were pressured by the police, or because the sun was in their eyes, or because somebody slipped them $50. Who knows? Whatever it is, they recant their testimony. That's a new issue. And the question for the post-conviction relief court is, had that been known at the time, would it have affected the verdict? So the new issues come in. New evidence. For example, somebody found a piece of evidence that was there at the crime scene that didn't get tested for DNA. They tested for DNA. They now have another source of DNA. Well, clearly that was the guy who did the bad deed because, even though the defendant's DNA is all over the murder weapon, this guy has a single fingerprint or a single piece of DNA on a pop can that was sitting to the right of the trash can in the house. So, you'll get new evidence claims that come in through post-conviction relief. But by far, the most common source of post-conviction relief is for ineffective assistance of counsel. And in that situation, what you're essentially claiming is, hey, my attorney was so bad. How bad was he? He was so bad that it violated my Sixth Amendment right to counsel. Because I had bad counsel, it's like I had no counsel. And indeed, that's the way the courts interpret them. So there are a number of things that a lawyer can do, or perhaps not do, that wind up being an ineffective assistance of counsel. They fail to properly investigate the case. They don't talk to the witnesses that the defendant tells them was there. My Aunt Jane was there, and Bill was there, and Bob was there, and unfortunately, if you don't go and talk to all of the witnesses and get witness statements or have your investigator do that, it can be ineffective assistance of counsel. Another potential source of error on behalf of the defendant is a failure to file a motion to suppress evidence, for example, the murder weapon or the cache of drugs because of an illegal search or some other technical law reason why they should not have allowed the evidence to come in, or to suppress the testimony of a witness, perhaps because they weren't qualified as an expert or for some other reason. If the counsel fails to do those things, and you remember, when this is done, the post-conviction relief attorney is a different attorney than the one who represented them at trial. So they have every incentive to find fault with their co-counsel. It's an odd situation. If they fail to identify and frame expert witness issues, if there was a DNA question that could have been resolved through an expert and they didn't name one or call one, or if they went past the deadline to file for that, then again, that could be ineffective assistance of counsel. If they failed to interview or call available witnesses, if they failed to object to improper evidence, and either because of hearsay or if they failed to object to improper opening statement or closing argument, if they failed to request a proper jury instruction from the trial judge, or if they failed to object to an improper jury instruction submitted by the state. All of these things are reasons when you are rationales for getting post-conviction relief through the courts. And of course, if for whatever reason you don't get relief from the PCR court, then you have the right of appeal. So one of the things you can argue, for example, is that the post-conviction relief counsel didn't do a good job. They basically abandoned the defendant. They failed to investigate. They failed to take out the constitutional violations that they should have. And then if that appeal fails, well, your next step is state habeas corpus. And basically, state habeas corpus is a writ you file in the state trial court, which will eventually get all the way up to the Supreme Court, usually, where you argue that you had due process violations or your right to counsel was impaired, your right to a fair trial, improper jury instructions, a lot of the things you've probably already raised, new evidence, claims based on stuff that was unavailable originally, improper sentencing, illegal detention, procedural errors, claims that errors in the legal process, such as the failure to follow the proper procedural rules during the trial or at sentencing, somehow impaired your case, claims of actual innocence, if you can now prove that it wasn't you, it was the one-armed man, then again, you can get relief through state habeas corpus. And I actually worked on a case when I was at the Missouri Supreme Court where somebody through state habeas corpus was able to get relief. And of course, errors in the legal process, prosecutorial misconduct is a common one there. Now, if all else fails, then the next shot, your last best shot, is federal habeas corpus. And federal habeas corpus has been guided by the Effective Death Penalty Act. And the issue in the Effective Death Penalty Act passed by Congress essentially said people are abusing habeas corpus, they're filing multiple habeas corpus petitions, and they're just using this to delay their date with the executioner. And frankly, this is how it has been that some murderers have escaped justice for 25, 35 years, dying in prison of old age rather than being executed, because people were abusing the federal habeas corpus rules. Well, now it's governed by federal law, and the first thing it requires is exhaustion of state remedies. So if you haven't exhausted, for example, a right to state habeas corpus, you can't get into federal court. And that's an important thing. So what happens is initially the federal court takes a look at your complaint and it determines whether you've met the procedural requirements, whether the claims are valid, whether you've met the filing deadlines. The state then responds to the petition and it says this is why the petition should be denied. Usually at that point the court makes a ruling and either allows the petition to go forward or it will conduct an evidentiary hearing. And of course, at any point, it can always dismiss the habeas corpus claim as improper. Now, interestingly enough, federal courts are supposed to defer to state court decisions unless they're contrary to or an unreasonable application of established federal or constitutional law as set forth by the Supreme Court. So if the state Supreme Court says in its review that the evidence was properly admitted under the state's evidentiary rules, well, the federal courts have to defer to that, unless there is a federal case or a Supreme Court decision that essentially says, no, that's a violation of the Constitution or due process or the right to a fair trial. Now, any claim that could have been raised at an earlier point in time and it wasn't raised in the state courts, it's now going to be barred in the federal court. And here's the other thing. You only get one shot. There is no second chance on federal habeas corpus. It's one and done. So if you don't make it this time, you're not going to make it at all. Those are the rights that keep prisoners petitioning for relief in death penalty cases, sometimes for 10 or 15 years. Because every time you go through one of these, it's probably 3 years. It's 3 years to get to the appeal. It's 3 years to get to the appeal of the denial for post-conviction relief. It's probably another 2 or 3 years to get to the state habeas corpus and get it reviewed by the state Supreme Court. And then it'll take another 3 or 4 years to get reviewed by the federal court. And then it goes up to the Circuit Court of Appeals, where it'll take another couple of years. And then it'll go up to the Supreme Court, where it'll take at least 1 and sometimes 2 years to get through. And then, only if you make it past all of those stops does the state actually get to put the needle in somebody's arm and take care of them. So, as you can see, there really are a lot of safeguards built into our system, and they are costly safeguards because the prisoner is going to be represented by an attorney paid by the state at every step in this process. And that's not an insignificant right. Now, does that mean that you're going to be represented by the very best of the best? Maybe not. But you will get a constitutionally proficient attorney. And one of the things that I think people often don't understand about this post-conviction relief thing, particularly as it applies in the state courts, is that not every witness that you fail to call is going to be ineffective assistance of counsel. For example, you have a witness that says that your guy was nowhere near the crime scene. He was in the back of the car with you, 3 miles away, and you guys were strumming on the ukulele singing Kumbaya, right? Your witness will say that, but the guy has a lot of priors. He was a confederate of the person who is charged with the crime, and you have a pretty good belief that he is not telling the truth. And so if you put him up, he is going to, as a witness, you're going to see him be impeached by the state for all of the prior felony convictions. And, even though prior convictions don't usually come in, if they come in for impeachment purposes, that's allowed. So again, it can be a strategic choice not to put a witness on the stand. And if the attorney comes in, and attorneys are required to come in and testify to what they did, why they did what they did, and if he says, look, it was a strategic choice, I didn't want to put him up and damage our credibility by putting up somebody who was very plainly lying. And of course, if he was lying and the jury determined that, they're going to know that my guy was the guy who did the crime. So the whole area of what they do after someone is convicted can be just as long and just as costly as the initial part of the criminal case. And it's not a pretty situation to be in, that's for sure, if you're the defendant. But by the same token, by the time you get to that position, in 99% of the cases, you've earned that distinction. That's what I'd say. So that's what I have for you today. Thank you for watching. If you have any questions, drop them in the comments down below. Like, share, subscribe, all that stuff. And Of course, if you would, I'd love for you to do a kindness for somebody today. Just reach out and help someone. After you do, come on back tomorrow. Join me at the beach. We'll talk about something else. If you were looking to hire a lawyer, would you look on the beach? Of course not. You'd probably come somewhere like this, where there's law books, secretaries, other lawyers, people dressed in suits. Of course you would. Because if you're looking for law advice, you need to go to a lawyer in your jurisdiction, somebody who knows the law there and who can advise you properly. And don't construe anything that I say here as legal advice. It's just general content on the law.